Hello everyone, and welcome to REMN Wholesale's webinar. For those that are hearing my voice but are not on the correct webinar, you should be seeing your presentation that says FHA Underwriting Changes. If you do not see that and you're on the different link, please check the chat box. There is a live link to the correct presentation. So if you can hear me but you don't see the presentation, go to the chat box, click that link, and you will be brought over to the correct presentation. So thank you all for taking time from your busy day for joining REMN's wholesale webinars on FHA guideline changes that take effect for case assignments on and after September 14th, 2015. So some housekeeping information. All your phones are on mute, and that's to limit the background noise. We have also had a lot of requests for a copy of this presentation already, so the good news is that not only will the recorded version be posted to REMN Wholesale website at www.remnwholesale.com, it'll also be sent out to all the participants via email. We also have a question box for you as well. Please feel free at any time during the webinar to ask your questions, and we will try to answer all of those and post the answers also to REMN Wholesale website. So before we begin, I need to ask a couple poll questions. The first one is, we want to know who is with us today. So if you can answer and vote. Mark, I know you're on the phone. Could you make sure? Okay, there we go. Okay, thank you everyone for answering that. We have a second survey as well, and that second survey is asking you, how familiar are you with the new FHA handbook, the new 4000.1? And if you could just take a moment to answer that as well. And after another couple seconds, we'll share that with you as well. So we're going to actually send the results to everyone. Pop box over there. Yep. And as we could see, we have 1% is an expert, and the other ones are kind of shared in between familiar, and they definitely need to know a little bit more about the FHA changes. So at this time, what I would like to do is I would like to introduce Carl Markman, who's the Director of National Sales for REMN Wholesale. Carl, are you there with us?
I am. Thank you very much, Pam. Appreciate it. Because of the overwhelming response to this particular topic, it happens to be the largest number of participants we've ever had on a webinar, and we're very proud of the history we've had with REMN Wholesale with training our broker and banker partners. All questions we ask you to still post, but we won't be answering the questions today, but we will be posting them and sending everyone a Q&A along with a tape version of this webinar. We appreciate everyone's attendance, and we appreciate Grace, our Senior Vice President and Chief Credit Officer, for taking the time today to present to us. Grace, are you there?
Yes, I am. Good afternoon, everyone. Thank you. So on this afternoon's presentation, what we will be doing is going over the new FHA changes that go into effect for case numbers issued on and after September 14th of 2015. This change is probably the most significant change that FHA has made that anyone can remember. They have consolidated over 450 different handbooks, mortgagee letters, and manuals, and the new manual is up to over 800 pages. Commonly, the industry has always referred to the 4155 as the go-to for underwriting standards. That manual is now gone and has been replaced with the 4000.1. Ironically, there are still many issues that FHA is still providing clarification on. As you can imagine, undertaking something this large required a lot of effort. Even as recently as this morning, FHA held an industry-wide training session where we learned some new information. So REMN Wholesale is going to provide you value now with the best efforts in explaining as many of the most significant changes that will occur with this new guideline. However, obviously we cannot hit all 800 pages in this seminar, so we really want to focus on what is occurring. And obviously we've got some really big changes ahead. During the course of this seminar, we're going to hit many things, but here's some of our top 10. Probably one of the most significant changes is how HUD will now look at student loans. There's new information on refinances, new definitions. Grossing up non-taxable income is going to change. In many aspects of the manual, there's something referred to as the 100-mile rule that's going to become important. We talk about changes in the authorized user credit account requirements. Streamlined refinances as well as cash-out refinances have some changes. Changes to self-employed borrowers. Expanded criteria for individuals who have promises of employment or offer letters. And a definition, an updated definition of what a family member is, which becomes important. I think it goes without saying, why do you need to know this? Obviously, it's going to affect borrowers' purchasing power or people refinancing maybe to buy a second home or investment property or just refinance their existing loan. One thing you want to be very, very careful of. Because of the changes, you may have pre-approvals out there, customers that you are working with, that at this point, once the September 14th changes occur, those borrowers may no longer qualify. Therefore, you really want to take the next couple of weeks to look at your book of business to determine, do you have borrowers that have not pulled the trigger yet and have not secured a case number? They may want to do that because they may unfortunately be shut out of the FHA market depending upon their individual criteria after September 14th. On the slide that we're showing, which will also be available on our website, you can go to the HUD site and obtain a copy of the new manual. It is public information. When you access the manual, you'll be able to look at it also in a PDF version, which will make it easier for you to search if you want to look up guidelines on your own, as well as a link to all regs where you can open up the manual and get your updates. HUD has indicated once this manual gets updated, there will no longer be the mortgagee letters that you're used to. They will make an announcement, and the change will actually occur in the 4000.1. So let's start talking about some of the more significant changes. We'll start with changes to dual employment or outside employment. With the new effective date for case numbers issued on or after September 14th, an individual will be able to hold dual employment in both the mortgage industry and the real estate industry. However, they will be prohibited from acting in a dual capacity and or receiving compensation for dual roles. So it's perfectly acceptable to hold both licenses. However, on a transaction-by-transaction basis, you would have to pick one or the other. This, of course, is also in addition to any other state laws that may apply. HUD has made their generic statement. Obviously, for the state that you're doing business in, if that superseded the HUD rule, then obviously your state would apply. This morning during the call, though, somebody raised a question and said, well, what would happen if somebody was the mortgage loan officer and their spouse, if they jointly owned a real estate company and their spouse was the realtor? HUD's comment this morning is they would get back to everybody, but their intent was the compensation could not be either direct or indirect. So at this point, that's one of the things they would get back for further clarification on, something I learned this morning. We talked about several of the refinance changes. One of the most significant changes, and during the presentation you'll see certain aspects of the presentation in red. That's so I can highlight some of the changes. One of the first things is under the no cash out transaction, which I'm sure this group is very familiar with. They now refer to something as called a simple refinance. A simple refinance is still an FHA to an FHA loan. However, it's not under the streamlined program. It would be used for a borrower who's fully credit qualified with an appraisal, and the only reason you would do that is to take advantage of some reduced MIP. Otherwise, you have your streamlined definition, And basically, you still have, obviously, it's only eligible for FHA to FHA. In all instances, an appraisal is never required. Loan limits no longer apply. There's an unlimited combined loan-to-value ratio. And the only real difference between credit qualified and non-credit qualified is if you're dropping a borrower from the existing loan, they would have to go into the credit qualified criteria, but you would still not be getting an appraisal. The one thing about streamlined refinances is they can only be done as a manual underwrite, and total scorecard, or what's commonly referred to as getting a DU, would not be applicable. On this refinance chart, and I know it's a little bit hard to see, but what we've tried to do, and again, you'll have the benefit of getting the presentation from our website, is we've tried to break down all of the ownership, the requirements of the different types of refinances, whether you're a no cash out rate and term, a simple refi, a cash out refi, or a streamlined refi. Some important factors to note is while they have opened up the cash out refinance option for a loan that has had a mortgage delinquency in the past 12 months, previously that was not allowed, it has to be downgraded to a manual underwrite, and you need extenuating circumstances. And I'm going to go through that again in a future slide because that was pretty noteworthy. But this slide will help you with understanding all of the requirements for the various refinance transactions and your maximum loan-to-value, cash-back allowances, maximum combined loan-to-value, etc. Another big change on the FHA update is lenders are now responsible for identifying the source of all electronically transmitted documents. So anything that has come in via a fax machine or technically an email, anything that may have a header on it, the lender is now responsible for going through a process of identifying that fax. We've always had to do that, but they've just expanded the criteria that the lender must go through. We've gone back to HUD to say, well, sometimes it's really difficult. If you get a PDF and it's attached to an email, but the PDF gets printed, how can you tell it was attached to an email? How do you know the borrower didn't hand it to you? So we've gone back to HUD for some clarification on this, exactly what they expect lenders to do, but as of right now, that's still an open item. Another big change regards borrower's authorization and Social Security requirements. They've expanded that the mortgagee or the lender must obtain a non-borrowing spouse's consent and authorization. We need to pull credit report on them, and we need to verify their Social Security number. Now, they've clarified that if a non-purchasing spouse does not happen to have a Social Security number or doesn't have credit, they can still do it. We just need to get some additional documentation. But if you're working with a customer and they have a spouse that is not borrowing or will not be on the loan, you still need to obtain authorization. Contract of sale, this was something that was fixed or clarified during this morning's session. HUD has now gone back and taken a position that basically everybody must be on everything. So all borrowers, all individuals who are on the contract as a purchaser must also be a borrower. They are only allowing an instance where someone would only be on title is if they are a family member. And family member is in quotations for a reason, because on a later slide you'll see where HUD has defined who acceptable family members are. So if somebody wants to just be on title and not be on the note, sometimes that happens because maybe the spouse has unacceptable credit, or they have excessive debt, which would, and not enough income to offset it, but they want to be on title. If they're a spouse, it's okay, but if it's a friend, it's going to be a problem. So we'll talk about what the family member definition is, but you need to remember now that unless they are an approved family member, everybody needs to be on everything. We talked about the fact about case number issuance date, and earlier I referenced know your customer. One thing you have to remember is you cannot pre-order a case number. There has to be a legitimate mortgage transaction, meaning a borrower that has applied for a specific property. So if you had somebody who was thinking about buying a house but wasn't prepared to pull the trigger, and you thought, well, let me lock up that case number so they're not subject to the new guidelines, that is not permissible. So you have to make sure that you have a legitimate transaction with a borrower who has gone into contract to purchase a property, or of course a refi would be separate. Case numbers automatically cancel after 6 months. One of the services REMN Wholesale offers is we will generate a report every month about case numbers that are about to expire due to inactivity. If a case number expires, it will not be reinstated by HUD. Therefore, if you happen to have a file, let's say it has a case number right now, maybe the transaction has some difficulties that you're trying to work through, and the application has gone a little dormant, you're going to want to make sure that that application, that case number is updated so that it doesn't expire, because if you let the case number expire and the deal resurrects itself, you are subject to the new guidelines. So that's something as I said, the REMN account executive can provide that information on our book of business. It's something that is very important. The other thing is, although HUD implies that the FHA Connection site will be open over the weekend, the fact of the matter is, if I were doing this, I would make sure that I've secured my case numbers by Friday, September 11th. You certainly could try and go to the site over the weekend, but just in case it's not available, I wouldn't wait for the last minute. You just don't know what's going to happen. And again, once September 14th comes, that is the effective date. Let's talk about borrower eligibility and some of the changes that have been made there. If you have a borrower that is active military, if they are deployed more than 100 miles from the subject property, it can still be considered an owner-occupied property if they have a family member that will reside in it. However, if they don't, they're ineligible. So let's take an example. You have a married individual who is deployed more than 100 miles away, and their family will be residing in the subject property. That is perfectly acceptable. You have a single individual who is deployed more than 100 miles away. They are not eligible because they will not have a family member residing in the subject property. If you have a single person that's deployed and they are deployed less than 100 miles away from the subject property, that's acceptable. They do not need a family member to reside. Other areas where somebody would be considered ineligible: borrowers with delinquent federal non-tax debt. They are ineligible until the delinquency is resolved. Now notice it says resolved and not necessarily paid off. So if the debt is fully charged off, that is a way to resolve it. But if it's an open delinquency, on a federal debt, maybe an SBA loan or a student loan, they are ineligible until that issue is resolved. Any borrower that's currently delinquent on any FHA loan, again, the delinquency must be resolved. An acceptable modification or repayment plan is an example of something being resolved if it's showing as delinquent, whether it's the subject property, if you were doing a refinance, or any other property. That borrower is ineligible until the delinquency is resolved. Borrowers with delinquent federal debt are ineligible unless they are in a valid repayment program with the IRS. And by valid repayment program, one of the criteria is that they must have made at least 3 payments timely in that payment program, and they cannot pay ahead. We are waiting for clarification from HUD as to what that 3-month clock is. Is it to application date, is it to case number date, or is it to closing date? We don't know yet, but we do know they have to make 3 payments and you cannot pay ahead. If the IRS has filed a tax lien, FHA is the one agency that will allow that tax lien to remain open, again, provided they are in that acceptable payment plan. We've put together a chart here. Again, you'll have the benefit of it when you go to our website and look at the PowerPoint, where we've classified the different types of borrowers and their requirements. So obviously your traditional borrower, co-borrower, everybody is on everything. We can use their income, assets, and debts. And the only requirement is they must occupy the property unless it's a streamline. If somebody's a co-signer, meaning they're only on the note and they don't have ownership interest in the property, they must have be a U.S. citizen or have a principal residence in the United States. Same with a non-occupying co-borrower. You have to be in a situation where you either have to be a U.S. citizen or have a principal residence, and you are subject to a 75% LTV limitation unless you meet one of the exemptions for a single family. And if a loan has a non-occupying co-borrower, the LTV is limited to 75% on all 2 to 4 family properties. Also, if your non-occupying co-borrower does not have a credit score, they are ineligible, although admittedly that is not likely. You then have situations where somebody's on a co-mortgagor and they only want to be on title. The only acceptable instance of somebody being a co-mortgagor is if they happen to be a family member, and we'll define that down the road. Another example of the 100-mile rule that we have to talk about is instances where a borrower has more than one FHA mortgage. We run across this frequently. The same 4 exceptions to allowing more than one FHA mortgage exist, which are relocation, increase in family size, vacating a jointly owned property, or if they were a non-occupant co-borrower on the prior transaction, the other individual staying there and now the person wants to buy their house on their own. Those are all eligible exceptions. The difference is the relocation now has a 100-mile radius requirement, meaning if they have an existing FHA loan and they're moving 75 miles away, they are not eligible. So again, another example of how this 100-mile rule is coming into play. Here's a list of what we have as family members that FHA has defined. Many of these are the existing rules that had previously been applicable. The only difference is FHA has now specifically indicated that cousins are out, in-laws are now in. There had been a point where mother-in-laws and father-in-laws were not included. We're not sure if HUD didn't like their in-laws, but now they've changed their mind, and in-laws now constitute a family member. And family member definition is important for things like identity of interest, gift of equity, non-owner occupant co-borrower requirements. So you'll have to be looking at that information for family members. The identity of interest rule still is in play. LTVs are limited to 85%, including tenant-landlord relationships, unless it falls under one of the exemptions. And you have, again, your family member exemptions as long as they've been, they meet the criteria if they're buying the family member's primary residence, or they can prove they've been in the dwelling for 6 months. Builder employee, an employee of a builder buying a new construction home. Corporate employee, sometimes you have transferring employees buying one another's property, which is fine. And that tenant-landlord exception would be that the borrower has been a tenant for 6 months prior to the execution, and they would have to prove occupancy. So if there is a relationship between the parties and it does not fall under one of those 4 exceptions, you are limited to an 85% LTV. I'm sure many of you can relate to this next picture of what do you mean we need more documents. It just seems like we kill a forest every day as we're going through documentation. One thing that's very, very important, regardless of what the DU engine said, regardless of what Total Scorecard says, the list here represents instances where the lender is mandated to drop the file down to a manual underwriting, which based upon the new manual underwriting guidelines that went into effect a little while ago, a lot of DE underwriter discretion is no longer applicable. So sometimes people get into a false sense of security and they believe, well, I have an approved eligible, so therefore everything's okay. That's not necessarily true. An approved eligible is not a get-out-of-jail card. Here's some examples. So let's just say, for argument's sake, that the engine happened to issue an approved eligible, but when the DE underwriter looked at the credit report, there were disputed derogatories that had a cumulative balance of $1,000 or more. Even though the credit report showed that, and the argument might be, well, the credit report showed it, Total Scorecard saw it, we should just be able to accept our approved eligible, that is not true. It has to be downgraded. Other examples of a required downgrade is a bankruptcy, foreclosure, not meeting the time frames, if you have mortgage delinquencies. Now, the one thing about the cash out, which is kind of unique, is in one section of the manual, it now says a cash out that has a delinquency within 12 months of assignment can be downgraded to a manual, yet in another part of the manual it says you cannot have mortgage delinquencies. So it seemed contradictory. In this morning's session, what HUD basically said is, look, Total Scorecard can never reject a loan. So all they're going to do is say, look, you have a delinquency on a cash out within the past 12 months. You have to downgrade it to a manual. Once you downgrade it to a manual, the only way it is eligible under the manual underwriting criteria is if the borrower met the definition of extenuating circumstance, which I'll explain a little bit later. So therefore, here's an example of maybe you're working with a borrower and they had a mortgage delinquency within 12 months. Somebody runs it through DU and you get an approved eligible and you're thinking, hey, we're in great shape. Well, you're not, because unless that borrower's delinquency was tied to extenuating circumstance, once the DE underwriter gets the file, they are required to manually downgrade it, and if you don't have extenuating circumstance, the loan is going to be declined. Another interesting one is that last bullet. If business income shows a greater than 20% decline over the period that the income is analyzed, you have to downgrade, even if the borrower qualifies at the 20%. So sometimes you might think, well, what's the problem with downgrading? Well, a year and a half ago, HUD changed their rules and basically took away a lot of the underwriters' DE discretion. Frequently we'd have underwriters, and if you could build enough cases, you could approve loans over a 50 back-end ratio. You could do a lot of creative things, and HUD's really taken a step back on that. So when you have a file that has to be downgraded to a manual or was a refer to start off with, there's some things you need to be aware of. Number one, regardless of the ratios, you have to have minimum reserves of either 1 month or 3 months, depending upon how many units the subject property is, and those reserves cannot come from gifts or proceeds from a refinance transaction. When the ratios exceed 31:43, there are minimum compensating defined factors that must exist, and I'm going to go over those in another slide. And if those don't exist, or you exceed the caps on the ratios that I'm going to show you, the DE underwriter cannot approve the loan. That discretion has been eliminated. Now, I'm showing you a slide with FICO scores. Keep in mind that we as an organization may have overlays once a file is in those lower FICO buckets, but what HUD is saying as an example is if the borrower, let's say, has a FICO over 580, okay, so it could be all the way up to 699 for that matter, but it had to be downgraded to a manual underwrite. You must have at least 2 compensating factors, and your ratios can never go over 40 and 50 individually. So let's look at that. On the prior slide, here are some examples. I talked about acceptable compensating factors, reserves in excess of the minimum, minimal increase in housing, no discretionary debt, etc. You would have to have at least 2 of these compensating factors on a manual underwrite with a score over 580, regardless of how high the score goes, and no matter how many compensating factors you had, your DTI would be limited to 40 for a front ratio and 50 for a back ratio. That's why it's extremely important that when you have a file, number one, if it gets a refer, that you're looking at it to make sure that it meets these requirements, or number 2, if you have an approved eligible and it's subject to a manual downgrade, you again check these requirements, because you could be wasting a lot of people's time, energy, and money because the loan unfortunately no longer qualifies and the discretion of the DE underwriter has been handcuffed by HUD. Of course, we still have waiting periods. This chart again will go through the waiting periods when you have a file, depending upon the type of derogatory credit you have. There are the standard waiting periods of either 2 years or 3 years, depending upon the negative. If you have extenuating circumstances, however, those numbers could be reduced. However, so when you have a Chapter 7 or 11, if you have less than 2 years but greater than at least 1 year, you have to downgrade it to a manual, and you have to document extenuating circumstance. Extenuating circumstance is something like death or serious illness of a wage earner. Divorce is not an extenuating circumstance, and HUD has specifically spelled this out. When you have your Chapter 13, you need at least 1 year out of payout with extenuating circumstance, and again, they're looking for things such as the serious illness of a major wage earner or the death of someone. Divorce is not an extenuating circumstance. If you have someone who had a foreclosure, deed in lieu, pre-foreclosure, or a short sale that was delinquent at the time of the sale, if it's less than 3 years, again, you have to be downgraded to a manual, so keep those factors in mind that I spoke about on the prior slide. But the extenuating circumstances not only cannot include divorce, but the inability to sell the property because it's underwater is not an extenuating circumstance. So even if the borrower said, well, I tried to sell my property, I couldn't, I listed it, we tried everything, but we had to let it go. If that loan was delinquent, that is not an extenuating circumstance, they have to wait 3 years. Now, the good news is if somebody has to go to a short sale and they had kept their mortgage current during the entire period and it just went to short sale, not a foreclosure or deed in lieu, but just was an approved short sale, there is no waiting period. Let's talk about analyzing some of the debts and some of the changes that we have going on. Authorized user account. Normally when you pull a credit report, if somebody was just listed as an authorized user, you didn't hit them with the payment because the belief was at the time they were not legally obligated for the debt. HUD's changed their position because the authorized user, their statistics showed that people, I guess, eventually did make the payments. So what they're saying now is, look, if someone's an authorized user, you must hit them with the debt, or you have to get 12 months worth of statements showing the other individual, the owner of that account, made timely payments. If they did not, you have to hit them with the debt. So this is obviously something that could be a big deal, and some people may not want to give up their 12-month statement, so you have to consider it. Installment debt that's going to be paid off in 10 months or less does not have to be considered. However, the cumulative payment of that has to be less than or equal to 5% of the borrower's monthly income. If it's over that, even if it's going to be paid in less than 10 months, you have to hit them with that payment. For the sake of time, I'm not going to go through every single line item. We can look at it. I'll try and focus on the most important. Another big thing, deferred debt, student loans. This is a huge change, probably the most significant for FHA. Currently, as many of you know, if a loan is in deferment, you were not required, if it was going to be in deferment for 12 months, you were not required to hit the borrower with the payment. After September 14th, that is no longer true. You must hit them with, if they are in deferment, with 2%. So let's say somebody comes to you, their student loans are in deferment, they have $50,000 in loans, times 2% equals $1,000. You have to hit them with $1,000 student loan payment. Now, let's say they are an income repayment, and that's an instance where somebody's in a repayment plan, but they've appealed to the government agency, given income information, and they can get a reduced payment. If that payment is zero, today, HUD says you can qualify on zero. So we certainly envision a number of instances where if people are in deferment and they no longer qualify, they may voluntarily offer to go into income-based repayment because in my example it would be less than $1,000. However, I caution everybody. At this morning's session, HUD admitted they see a big loophole in their theory about hitting somebody with 2% if they're in deferment, but allowing a zero payment on income-based, and they indicated that they were re-looking at that requirement. So I have no way of knowing if or when they're going to require it, but certainly the reference this morning was they realized that maybe there's an inequity there. So certainly I'm not suggesting you volunteer, tell everyone to go out and put themselves in income-based if they're not there already, but you want to make sure you're aware of it. Student loans, let's face it, are a big factor in qualification. Revolving debt that does not have to be repaid in full every month, of course, that you just use your credit report balance or 5%. But your demand accounts, the accounts that normally traditionally say have to be paid off in 30 days, because many of these creditors, such as Amex, now offer, even though it's a demand account, they offer minimum payments. It's a little crazy. They require that you even reoccur that payment unless you can provide 12 months worth of statements showing the balance was paid in full every single month. The fact that the credit report shows it was current every 12 months is not enough. You need to get 12 months worth of statements to show that it was paid in full. Otherwise, you have to hit them with that payment. Another individual thing we want to remind everybody on is the requirements for any type of contingent debt. Normally, those are debts that somebody has co-signed. Basically, you're going to have to hit people with those contingent debts. If somebody co-signed a debt, the first rule is the co-signed allowances only apply in a true co-signed situation. So let's say mom and dad buy a car for their child, and the note is only in mom and dad's name. But they're going to give you 12 months worth of checks showing the son has been making the payments. Since the son was never on the loan, You don't have a co-signed situation. Mom and dad just have a note. Therefore, they're going to be hit with the payment no matter how many payments the borrower, that the son in my example, has made. But in my example, if mom, dad, and the son all sign the note, and then the son can give evidence of 12 months worth of canceled checks, and our borrower is mom and dad, then you would not have to hit them with the repayment. A business debt, clearly when the borrower has a debt in their own personal name and it's paid by the business, HUD is now allowing where you can not include that in the borrower's DTI ratio, provided you have the business tax returns, it shows the obligation, and you also consider the cash flow. HUD hasn't told us how long we have to consider the cash flow, so we need clarification on that. Big changes in income, part-time income. It has to be uninterrupted for 2 years, otherwise you cannot use it. Overtime and bonus, they would prefer 2 years, but you have to have at least 1 year, otherwise you can no longer use that income to qualify. Another change on commission income, they've clarified that again, first of all, they've defined the commission income rules, meaning if it's less than 25%, you can just use your traditional income documentation, but if it's 25% or more, regardless of how you looked at it, you have to turn around and get your tax returns. And if it's earned less than 1 year, they are not going to make that income eligible. Family-owned business continues to be allowed. However, regardless of what the DU says, you must get the borrower's tax returns and verification of no ownership. You cannot just get away with W-2 or pay stub. Self-employed borrowers, they prefer 2 years, but they've turned around and made an allowance for 1 to 2 years, but they've eliminated education training in that time frame. If somebody is self-employed less than 1 year, that income is ineligible, regardless of what kind of prior experience they have. If there's a greater than 20% of decline, so if you're analyzing it over 2 years, which most of the time you do on self-employed borrowers, if you have a 20% or more decline, even if they qualify at that lower amount, you have to downgrade it to a manual. And again, I caution everybody, all of those requirements on manual, including your caps on DTI. They still will continue to require a year-to-date P&L and balance sheet through the most recent quarter. So as an example, today, the most recent quarter would require that besides the 2013 and 2014 tax returns, you would have to require a P&L statement with a balance sheet through June 30th of 2015. However, if the borrower files a Schedule C, you would only need the P&L. They've removed the requirement for Schedule C. They removed the requirement for a balance sheet for Schedule C borrowers. Temporary income, they've clarified again that you can use short-term disability or maternity leave as an example. You do need your letter on intent to return and the borrower's employer confirming their right to return. What you use to qualify will depend upon when they're due to return. If they're due to return before the first payment, you can take their pre-leave salary. So the most common example is an individual's on maternity or paternity leave. They're currently getting short-term disability, but they're going to go back to their job before their first payment. You can use the income from their job. However, if they're going to return after the first payment, you basically use their current income, which may be disability income and not their income when they return to work. You can supplement that with some required reserves. There's information in the manual to show how you can supplement that, but they've clarified that, all the requirements in the new manual. They've made a change to alimony and child support. They've turned around and basically said that no matter what, if it's not paid in a timely manner, you have to average it over 2 years or since inception if less than 2 years. Sometimes people agree to do, higher payment, lower payments, and the fact that they've agreed is fine. You have to unfortunately average. Expected income increases. Well, that's the good news. You can now, if you can document that increase, whether it's a new job, a raise, cost of living increase, is going to occur within 60 days of the closing, you're allowed to use that higher amount provided they're not employed by a family member. Unfortunately, though, on non-taxable income, they have reduced the grossing up. The maximum factor has been reduced from 25% to 15%. Rental income of the subject property, they've made a lot of changes. If the rental income for the subject property, if they have no history of collecting rent, there are requirements on what you have to do as well as getting appraisal forms. If you have a history of getting rental income, which of course would be a refinance situation, you do have to get 2 years tax returns. If it's owned less than 2 years, the tax returns since inception, and then you're going to average the income that has been listed on the Schedule E. Rental income from other property, again, that 100-mile rule is going to come into play again. If they are vacating their current residence, whether they're vacating a single-family property or they're vacating one unit in a multi-family property they own, in order to use any rental income, they have to be moving more than 100 miles away. Otherwise, you cannot use the rental income, but of course, you are still going to hit them with the debt. Then there are requirements if there's a history on the tax return, what you require to calculate the income based upon whether you have a history of receiving income on that property or not. So on a 1 unit, it would be an appraisal report. 2 to 4 unit, you'd have to get an appraisal statement, as well as you can use that or 75% of the market rent or the lease. If you have a history, again, they're going to require the 2 years tax returns. Assets, this is not a biggie. What you have here is, of course, the borrower cannot have their minimum cash investment coming from an interested party. If the earnest money deposit now exceeds 1%, you have to document it, or if it looks unusual based upon the borrower's savings pattern. So an example we gave this morning at the session was, let's say the deposit, it was less than 1%, and it was $500. Well, $500 is probably a reasonable number. Everybody would hope to save that. But let's say it was less than 1% and it was $4,000, and the borrower only made $20,000 a year. They're probably going to ask to verify that deposit. And large deposit is defined as 1% of the adjusted value of the property value. Big change on gift funds. They've now absolutely specifically stated that regardless of when the gift is given, the lender is responsible for making sure that the gift did not come from an unacceptable source, which effectively means that mortgagors have the right and the obligation to source a large deposit in a donor's account. Because obviously the concern is if the donor's account has a large deposit in it, where did that money come from? Did it come from they transferred money from another account, which would be perfectly acceptable? Or number two, they got that money from an unacceptable source but gave it as a gift to try to circumvent the policy. Therefore, effectively, no matter how the gift is given or when it's given, any large deposits in the donor's account must be sourced in order for a lender to verify it did not come from an unacceptable source. Here are the different things that you have to do with regard to the transfer of the gift, whether the funds are in the borrower's account, not in the borrower's account, or are paid directly to the settlement agent. But again, no matter what, a big change here is you do have to source the donor's account if there's a large deposit. If you have a donor's bank account and there's no large deposits in there, you don't have to source it any further other than getting the evidence of their account. And then finally, on interested party contributions, they're reminding everybody about your 6% cap. However, interested party contributions cannot be listed and cannot be considered as part of the borrower's minimum investment, and now must be completely itemized on either the HUD-1 or the closing disclosure, which will come into effect once the TRID guidelines come into effect on October 3rd. And with that, we concluded our the session regarding the PowerPoint itself. We do remind individuals that you can now, besides the questions that have been typed into the chat box, which we will gather and post on our website, you can go to FHA questions at remn.com, list your questions, and again, besides posting our PowerPoint and this recorded video, we will be updating on a frequent basis some FAQs. With that, I'd like to turn the meeting back over to Carl for him to wrap up our presentation, and I thank you for your time.
Thank you so much, Grace. We're so lucky to have you as a presenter today, and we're committed to educating our broker and banker partners. If you're looking for consistency with training and guidelines and turn times, then please go to our website and click on Become a Partner, because we offer for years now same-day turn times every day on initial underwrites. We're specialists with FHA 203K and Fannie Mae home-style products, as well as most other programs. We thank you very much. You're part of one of a record breaker for us to have as many people on this webinar today, and keep those questions coming because we will be sending out the Q&A after this presentation. Thank you so much, everyone, and have a great day.